Good day everyone. For this video, I will be discussing another mode of extinguishment of obligation, and that is confusion or merger. Section 4. Confusion or merger of right. Article 1275. The obligation is extinguished from the time the characters of creditor and debtor are merged in the same person. Confusion or merger is the meeting in the same person of the qualities of creditor and debtor with respect to one and the same obligation. The obligation is extinguished if a debtor is his own creditor and enforcement of the obligation becomes absorbed, since one cannot claim against himself. So, confusion or merger, muna dyan ang the debtor becomes his own creditor and therefore enforcements becomes absorbed because if you are your own creditor or debtor, so how will you enforce payment from yourself? Muna the law in this case considers such as confusion or merger a mode of extinguishing obligation. Let's go with the requisites of confusion or merger. Number 1, the merger of the characters of the creditor and debtor must be in the same person. So, the qualities of the creditor must not have been transferred to the third person, and neither should the qualities of transferred from the debtor to the third person. Okay, it should be the qualities of the creditor and the qualities of the debtor are merged into one. So, in number 2, the merger must take place in the same person of either the principal creditor or the principal debtor. So, when we say principal, there are co-debtors, there are co-creditors. These are not the ones contemplated by confusion or merger. In order for there to be valid confusion or merger, the merger must not take place between the person of principal creditor and principal debtor. In number 3, the merger must be complete and defined. These requisites does not require that the obligation be totally extinguished, because what this refers to is that the transferring of qualities of either the creditor or the debtor into the same person, that is what be complete. Let's proceed sa Article 1276. Merger which take place in the same person of the principal debtor or creditor benefits the guarantors. Confusion which takes place in the person of any of the latter does not extinguish the obligation. Who is a guarantors? He is a person who stands to answer for the debt of the debtor in case the debtor is unable to pay. If the person of the principal creditor and the principal of the debtor have merged, then the guarantors are relieved of their responsibilities. They have no longer to fulfill the duties of being a guarantor. So, Article 1277. Confusion does not extinguish a joint obligation except as regards the share corresponding to the creditor or debtor in whom the two characters concur. In Article 1277, in a joint obligation, a debt or an obligation is divided into as many of obligation as there are creditors and debtor. Each is only liable for their proportionate share. In case a donation happens in joint obligation, since the debtor are only liable for their proportionate share, that proportion pertaining to the joint debtor is the only portion that is extinguished. The other portion is pertaining to the other co-debtors are not extinguished. In solidary obligation, if the confusion takes place in one of the solidary debtors, the entire obligation is extinguished. So, in solidary obligation, there is only one debt. So, in case that the singular debt has been condoned, then the obligation itself is extinguishment, prejudice to the rights of the debtors and creditors among each others. So let's proceed to another extinguishment of obligation. Section 5, compensations. In compensation, there must be two persons who in their own right are creditors and debtor of each other. Article 1278. Compensation shall take place when two persons in their own right, are creditors and debtors of each other. So in compensation, the extinguishment to the concurrent amount of debts of two or more persons who are in their own right will to show the creditors and debtors of each other. In other words, the debtor already has a debt in favor of the creditor. For some reason, the creditor has the debt in favor of the debtor. In order to prevent unnecessary litigation, where both have to file claims of each other, the law of Article 1278 set off each other claims against the other. Kinds of compensation classified is effect or extent. Number 1, by its effect or extent, nasadya total or partial. Total when the two debts are of the same amount. 2, partial when the two debts are not of the same amount. So sa number 2, by its cause or origin. A, legal when it takes effect by operation of law from the moment all the requisites prescribed by law are present. B, voluntary or conventional when it takes place by agreement of the parties. C, judicial when it takes the effect by the judicial decree. D, facultative when the compensation can be set up only by one of the parties. So let's proceed sa Article 1279. In order that compensation may be proper, it is necessary 1. That each one of the obligors be bound principally, and that he be at the same time a principal creditor of the other. 2. That the both debts consist in a sum of money, or if the things due are consumable, they be at the same kind and also of the same quality if the latter has been stated. 3. The two debts be due. 4. They be liquidated and demandable. 5. That over neither of them there be any retention or controversy, commenced by third persons and communicated in due time to the debtor. So, Article 1279, this provision talks about the requisites of legal compensation. If there is one provision about compensation, Article 1279 enumerates the requirements of requisites of legal compensation, absent any showing that all the other requisites are present. Compensation may not take place, while a legal compensation absent of any of these requirements. I will discuss one by one of these requirements. Number 1. Simply put, that the parties are principal debtor and creditors of each other. For example, the A owes the B of 10,000, unya ang the B naapoy utang sa A og 10,000. So compensation will take place because sila ang principal debtors and creditors of each others. Sila mismo ang principal debtors and creditors bawat isa. So sa number 2, kung consumable things daw, dapat same kind of quality. Example, A obliged himself to deliver to B 20 sacks of rice. On the other hand, kinipod si B na asjay obligation kay A to deliver at 20 sacks of corn. Dire way compensation kay ang obligation nilang duha are consumable things pero not of the same kind and quality. Kay kang A, kay 20 sacks of rice, then kay B, kay 20 sacks of corn. So, let's proceed sa number 3. Due means period has arrived or condition has been fulfilled. Demandable, no debts has prescribed. Debts are valid and legal. For example, A owes B 100,000 payable on December 25, 2024. The B owes A 100,000 payable on December 30, 2024. So, can there be legal compensation on December 25, 2020? Dili pa. Wala pa'y compensation. Kay one of the debt is not yet due, kaysa December 30 pa, mahimong due ang demandable ang utang ni B kay A. Liquidated. The debt can already be determined or ascertained. For example, A owes B 5,000 and si B owes A og 5,000. Si B, bayaran ni dya si A og share ni A sa ilang business. Apan, which yung amount kung pila dili ma-ascertain, so dili pa liquidated. Kung pila ang share ni A sa business nila. So, compensation will not take place as the debt of B to A is not yet liquidated. If part of the debt of B has been liquidated, compensation takes place with respect to that part without waiting further liquidation of the rest of the entire obligation. So, number 5. So, no retention or controversy has been commenced by a third person. So, this is the negative requisites for legal compensation. For example, A owes B 1 million. Unya, si B owes A 1 million pod. Pero si B naapod si J utang ni C og 1 million. So, yung credit has been varnished by C, who proclaims to be an unpaid creditor. Nag-file og CC o garnishment proceedings against a credit ni A kay B. So, compensation cannot takes place between A and B because na ay controversy which is commenced by C because nag-file si siya og garnishment proceedings. So far, the meantime, the compensation is suspended. So, let's proceed na po sa Article 1280. Notwithstanding the provision of the preceding article, the guarantor may set up compensation as regards what the creditor may owe the principal debtor. It says compensation benefits the guarantor, although the guarantor is only subsidiary. He is not principally bound. He is given the right to set up compensation. The reason is that extinguishment and principal obligation as the consequence carries with the accessory obligation as a guarantee, so the guarantor is given the right to set up compensation. For example, A owes B 1 million and C is the guarantor of A. Then, B in another transaction also owes a 300,000 katong naningil na si B kay A o 1 million. Si A dili makabayad, so as a guarantor ni A, the question is how much C be liable. So si C will be liable for 700k only. Kay pwede i-set up ang 300k pesos na credit ni A as the basis of partial compensation. So 1 million minus 700,000 mo nang 1 million minus 300,000 minus 700k only ang mabayaran ni C. So, Article 1281. Compensation may be total or partial when the two debts are of the same amount. There is total compensation. Kinds under Article 128 of the Civil Code, we have total or partial compensation. In this case, the debts are equal in the amount or value, then they will be totally compensated, which also results in total extinguishment of the obligation. Where there is smaller debts and the larger debt, there will be total compensation. As to the first smaller debt, and there will be partial compensation up to the amount of the smaller debt in cost of the larger debt. So there is partial compensation and the obligation is also partially extinguished. Article 1282. The parties may agree upon the compensation of debts which are not yet due. This is voluntary compensation. Requisites under Article 1279 dili siya mag-apply sa voluntary compensation because this kind of compensation has no special requisites due to its sufficient agreement of contract mismo sa duha ka parties, which ang contract mismo nag-declare ng compensation should be valid or should itself be valid. Article 1283. If one of the parties to a suit over an obligation has claim for damages against the other, the former may set it off by providing his right to said damages and the amount thereof. So, Article 1283, this is a judicial compensation set off. So compensation may also take place when declared by a final judgment of the court. The Article 1283, a party may set off his claim for damages against his obligation to the other party by proving his right to set damages and the amount. So all the requisites under Article 1279 must also be present. Exception: at the time of pleading, the claim is not yet liquidated, kaya ang liquidation or pagdetermine sa amount must be made in that proceeding. So Article 1284, when one or both debts are rescissible or voidable, they may be compensated against each other, therefore, before they are judicially rescinded or avoided. So, compensation of requisite. So, Article 1284, compensation of resistible or voidable debts. Hinumduman lang nato na resistible or voidable debts, the same with resistible or voidable contracts. They are valid until annulled, valid sila until rescinded or voided. Since valid man sila until voided, compensation is allowed. Kay at that time, valid pa man ang status nila, pero to avoid unfairness naman if ever ang rescission or annulment was later on decreed by the court after compensation tapos na declared void and debts or deceasable and avoid or rescinded ang debts, then it is as if no compensation ever took place. So, Article 1285, the debtor who has consented to assignment of rights made by a creditor in favor of a third person cannot set up against the assignee the compensation which would pertain to him against the assigner unless the assigner was notified by the debtor at the time he gave his consent that he reserved his right to the compensation. If the creditor communicated the cession to him, but the debtor did not consent thereto, the latter may set up the compensation of debts previous to the cession, but not of subsequent ones. If the assignment is made without the knowledge of the debtor, he may set up the compensation of all credits prior to the same and also later ones until he had knowledge of the assignment. This provision talks about the effect of the assignment of compensation of debts. Article 1285 has three scenarios. The first scenario is naa sa first paragraph. The assignment may be made with consent of the debtor. The first is dapat na i-consent ni debtor. Kuno. So, number 2, assignment was made with knowledge but without the consent or against the will of the debtor. Walay consent pero knowledgeable kahibaw siya sa assignment. So, number 3, the assignment may be made without the knowledge of the debtor. Third, walay alamag na or wala siya kahibaw sa assignment. So, Article 1286, compensation takes place by operation of law, even though the debts may be payable at the different places, but there shall be indemnity for expenses of exchange or transportation to the place payment. This article applies to legal compensation, indemnity for expense of transportation. It applies at transportation ng goods or objects. Ang indemnity for expense of exchange mao ni ang expenses for monetary exchange, like if the debts are money. For example, A owes B $1 million payable in New York. Then si B na si J utang ni A o 100 pesos in an equivalent amount payable in Manila. If A claims compensation, he must pay for the expenses of exchange. Whoever claims compensation, siya ang mubayad for the exchange rate of currency or for the transportation. Article 1287, compensation shall not be proper when one of the debts arises from a depositum or from the obligation of a depositary or of a bailee in commoditum. Neither can compensation be set up against a creditor who has a claim for support due by a gratuitous title, without prejudice to the provision of paragraph 2, article 301. So article 1287, this provision talks about instances or situation when legal compensation cannot take place. Sa first paragraph, when one debt arises from depositum or contract of deposit is yung nag-deposit ka og usa ka butang to another and ang purpose is for safely keeping and returning the same. The second, when one of the debt arises from the comodatum. Comodatum is a gratuitous contract where one of the parties delivers to another something not consumable so that the later may be the same of the certain time and return it. The third scenario, which one debt arises from a claim for support due to by gratuitous title. Article 1288. Neither shall there be compensation if one of the debts concealed in a civil liability arising from a penal offenses. So, Article 1288, one of the debts is assessed in a civil liability arising from a penal offense. Dili siya pwede ma-compensate walay legal compensation in this situation. So, Article 1289, if a person should have against him several debts which are susceptible of compensation, the rules of the application of payments shall apply to the other of the compensation. So, sa Article 1289, diri naghatag og cross-reference to application of payments. So, rules on application of payments also applicable sa compensation. So, for example, if A is may utang kay B, amount of 1,000 without interest. Anya, ang ijang usa ka utang is 1,000 po na ay interest nga 6%. If si B pod ang ay utang kay A og 1,000 and maupod ang due ni Ja, then walay nag-inform kung asa sa duha ka debts ang i-compensate ni B. Ang ingon sa the most onerous daw. So, sa example nako, ang sa second which is ang naay 6% mao ang i-compensate. Ang nabilin na laman yung utang ni A is 1,000 na lang without interest. So, sa Article 1290, when all the requisites mentioned in Article 1279 are present, compensation takes effect by operation of law and extinguishes both debts to the concurrent amount, even though the creditors and debtors are not aware of the compensation. So, sa Article 1290, since na-discuss na nako ang Article 1279, the legal compensation takes place by operation of law. Compensation occurs automatically by mere operation of law from the moment that all requisites mentioned in Article 1279. So, legal compensation takes place biskan absence or kahit walay agreement between the parties, and even if it against their will, it will extinguishes reciprocally both as soon as they exist simultaneously. Ingon pod na it extinguishes concurrent amount. When we say concurrent amount, it means ang usa ka debt is dako kaysa usa na as J balance, and that balance will be subsist mabilin. That's all. Mora to ang another mode of extinguishment of obligation, section 4 and section 5. Thank you.